Welcome to the Animal Law Podcast. This is Marianne Sullivan. Today I'll be speaking once again with Animal Legal Defense Fund attorney Kelsey Eberly, but today she will be joined by Dave Muraskin, who's an attorney with Public Justice. They'll be discussing the rather disappointing, unbelievably disappointing, very, very upsetting decision in the District of Columbia Superior Court in ALDF versus Hormel Foods, which involves the very problematic advertising for Hormel's natural choice products and why they believe that decision was wrong and is likely to be reversed on appeal. This is a really important decision, and it relates directly to what is happening on factory farms, why we cannot allow agribusiness to continue calling it natural, and also relates in really important ways to the more general question of what animal advocates can do when they believe the public is being deceived about the conditions under which animals are being held. According to this decision, they can't do that much, so let's hope it gets reversed. Before we get to that interview, I'd just like to quickly ask for your support in helping us keep Our Hen House, which of course produces the Animal Law Podcast, along with the Our Hen House podcast, help keep it going. And if you can help out, please go to ourhenhouse.org/donate. There you can join our special band of supporters whom we call our flock, or you can make whatever donation you can afford and are comfortable with. But please try to do something. The only way to keep animal-friendly indie media going is through supporting its efforts. And in this case, that means Our Hen House and the Animal Law Podcast. So now to Kelsey Eberly and David Muraskin. As noted, Kelsey is an attorney with the Animal Legal Defense Fund, where she is involved in litigation in a number of different areas, including consumer protection law. And Dave is a food safety and health attorney at Public Justice, where he focuses on Public Justice's efforts to hold factory farms accountable for the negative social and environmental effects of their production methods. Prior to joining Public Justice, he worked on a variety of consumer litigation. He was the Alan Morrison Supreme Court Assistance Project Fellow, Public Citizen, and he was also an attorney in McCool Smith's whistleblower practice. And now to the interview. Welcome to the Animal Law Podcast, Kelsey and Dave.
Thanks, Marianne.
I have both of you here today, and it's a good thing because I'll tell you, I do try to get up to speed on cases before I do these interviews, and this was a challenge, I got to admit. There are a lot of weeds. I like to get into the weeds, but there are a lot of weeds in this case. There are a lot of issues, and I thought I knew something about standing, and now I'm pretty confused. Now, before I intimidate everybody into not wanting to listen to it, it's really an interesting case and a hugely important case. So let's just start off with some facts. This is about some advertisements and that concerned you and you felt were a problem. So can you just tell us about these ads?
In 2015, we became aware of this new advertising campaign that was going out under the banner, Make the Natural Choice. And this was, print advertisements in magazines and coupon inserts. It was online, YouTube videos. And all of these advertisements were sort of touting the Hormel Natural Choice line of lunch meat and bacon products as natural, sort of superior, no preservatives, no nitrates, something different than, your conventional factory farmed meat. And that concerned us because of what we, thought we knew, what we did know about Hormel's practices. So this was really an advertising campaign, spanning multiple media and really, premised on this notion of these products being the natural choice.
Yeah, and you spoke in my class the other day, Kelsey, which did really help me get up to speed on this case a little bit. And you talked about how, and this makes so much sense to me, the industry really wants to use this term natural. And is that true? And why is that?
We had seen, when we saw these advertisements, they were so concerning because we were aware of this pretty significant body of consumer surveys and research out there showing that consumers in large, majorities are interpreting the term natural, in a very reasonable way to say something about the way the animals are being raised, the things that are being fed, sort of the, many attributes of the production. So, when companies are using this term, it's sort of, a shorthand for, better production methods, more humane production methods. So, lack of antibiotics, lack of hormones. And that troubled us so much because we knew that, most or all of these products going out under this natural banner were produced using the same factory farming methods. And, the only difference was that they're preserved with cultured celery juice powder instead of sodium nitrate. So to us, that, that was a large source of consumer deception that was allowing, consumers to be fooled into buying inhumane factory farmed meat.
I'll just add here is that, this, as Kelsey mentioned, this case was brought under the consumer statutes. And so the real question in the core of the case was whether consumers are deceived. But as you're pointing out, what kind of motivated the case and what the case actually reveals is that there's a real intention to deceive. It's not just that consumers happen to be deceived, but that there's a real fraud here. And I don't use that term lightly at all. I mean fraud in the legal sense. One of the documents we uncovered is this North American Meat Institute presentation. North American Meat Institute is one of these, thank you for smoking type of trade group, facade groups. And what they say in that presentation is that factory farm producers should go out and attempt to use natural and associate it with better quality products, and then get consumers to think that natural has that better quality aspects, organic and the like, and then get consumers to buy the factory farmed, quote unquote, natural meat because it's slightly cheaper. Right? Where you have a real intention to use this term to get consumers, to dupe consumers.
Yeah, let's face it, if the term natural actually meant to consumers what it does mean, according to the USDA or whatever, they wouldn't have any interest in using it because it means close to nothing. So yeah, there's a real incentive. I totally see that. Did you do, you've mentioned like things that you found. Did you do any additional research into the beliefs of consumers about this term, either before the litigation or during the litigation?
So both, and I think that's one of the things that's come out. So there's now online a 600 plus page document which really contains Hormel's emissions. And I think that's one of the things that is most valuable to come out of this case so far is Hormel's own statements. And what that document reveals, and this is things that Hormel has decided to put into the public now because of this case, is that it consistently found that consumers had very detailed, explicit, and strong expectations of what natural should mean. It should mean animals raised without antibiotics. Hormel's director of marketing has this great email where she says, natural equals RWOA, raised without antibiotics. The consumer studies that Hormel does, and everyone should know that these groups are doing detailed, expensive consumer studies of how you're going to react to their ads before they run them. And the consumer studies Hormel did and endorsed consistently showed that consumers understood that natural meant more humanely raised or humanely raised, that animals got access to the outdoors, that there wasn't the use of hormones. All that's not true about natural choice meat and Hormel's, because it's just like Hormel's regular meat. It's just like Spam, and Spam's produced in the worst methods possible. And so we now know that Hormel very consciously set out to lie. And that's what we thought going in, and that's what we found out they were doing. And as you say, that as you pointed out, they're relying on this terrible USDA definition of natural, which basically says that natural can mean anything that's processed in a very kind of generic way that doesn't have artificial ingredients added. And then it's just natural. And that's not what consumers think, and that's not what Hormel was trying to convince consumers to think.
Okay, so that kind of sets the facts really well, why you went into this, why you decided to bring this massive lawsuit. But ultimately, we need to get to the law because the decision you got doesn't have a whole lot to do with the facts, sadly. Now, let's just lay out a little bit of the law of standing, which, as I said, I thought I knew something about it, and it turns out I know less than I thought I did. All right, the District of Columbia, it has this great false advertising law, so we really want to be able to bring cases there, but there are really serious complications about standing in D.C., which I didn't realize. The D.C. courts. Where does one bring lawsuits in D.C.? As if you were in New York and you wanted to bring a state lawsuit, it would be obvious you would go to the state court. So what do you do in D.C. when you want to do that? and they're not state courts, but are they federal courts? And let's talk about some of the implications of that.
Yeah, I mean, so, from our perspective, this is one of the strongest consumer protection lawsuits out there. And I mean, I think we still believe one of the ones that provides the broadest standing for individuals and entities to enforce its very strong substantive provisions. So, the DC Court of Appeals came out with this decision in 2011, sort of construing narrowly some of the standing provisions. And the DC Council reacted in 2012 to amend the statute to broaden standing even further, and to state that, entities should have standing sort of to the fullest extent of prior or future Article 3 decisions under the DC Federal Court of Appeals. But it is a sort of a tricky jurisdiction because on the one hand, there are Article 1 courts, but on the other hand, I
have to say, Article 1 courts was a new one on me. You learn something every day. I didn't know there were Article 1 courts, but there are, and DC is among them.
And on the other hand, they, sort of follow Article 3 standing, or they say they do. So, we were faced with, that fact, but then also this, consumer protection statute that very deliberately wanted to give standing, was trying to give standing to the greatest number of potential individuals or entities that could enforce it. And, we saw that the Animal Legal Defense Fund fit right under one of or two of those standing provisions. It is a nonprofit organization that was acting to, protect itself and consumers from the deceptive trade practices at issue in Hormel's Make the Natural Choice campaign. And it qualified as a public interest organization under the statute because ALDF, acts on behalf of and to protect consumers with regard to animal products on a very regular basis. And that's a sort of a core part of our work. So, we felt good about our ability to bring this suit. But, obviously the court felt a little bit differently.
Let me just see if I understand. So they're not Article 3 courts. They're Article 1 courts, but we don't have to understand that too much because they've decided to adopt Article 3 standing provisions for these Article 1 courts. So we can just assume even though they're not really federal courts in the way that other federal courts are federal courts, they follow Article 3. Okay. I know that was complicated, but I hope it was understandable. So that means that in order to have standing to sue in them, like in any Article 3 court, federal court, you have to have injury, causation, and redressability, which, is not necessarily true in state courts. And then you have this statute that doesn't really address that consideration, but seems to give very, very broad standing and doesn't make it all clear that you exactly, and makes clear that they want to go as broad as they can. So you have one thing pulling on the courts bestowing broad standing, these statutory provisions, which we will go into, and then this idea that they're acting like Article 3 courts, so it's leading towards narrowing standing. And you were trying to find the balance in there. Is that right? Does that make sense?
I think so. I mean, to be clear, we, because we can show Article 3 standing, and we are a nonprofit organization that, sort of is exactly the type of entity that the DC Council was intending to empower to bring these suits to, protect DC consumers. We sort of recognize the tension in the standing situation, I guess, but we felt strongly that we, whatever the standard was, we met it because we could show Article 3 standing. But it is, at best, sort of ambiguous about exactly what you have to show.
Okay.
Well, maybe just to jump in here, sure. I think to unpack this a little bit, and I think what Kelsey's saying is that at the most we would need to show is Article 3 standing. And ALDF has Article 3 standing under the doctrine of havens that provides it provides entities standing in federal court. But what this, DC courts are Article 1 because DC is not technically a state, but they should be treated as state courts, and they historically have looked to the DC Council, just like you would look to a state legislature and the DC, the orders and laws establishing DC as you would look to a state constitution. And this statute provides for more expansive standing. So kind of assuming that we have to be under Article 3, we think makes the error that the court here, and I was almost called it a district court, it's not a district court, it's DC Superior Court, but the court here did, which is to say Article 3 is what governs. And in our view, actually, what you have is Article 3 as modified by the statute, which basically says that a nonprofit representing the consumers in D.C. should be able to bring this challenge because we don't want consumers in D.C. to be duped the way Hormel's duping them. And that's what the D.C. Council was doing. I think Kelsey can better elaborate why we're so solid on Article 3. This was just a wrong decision, but we should have, that should not even be an issue here.
All right, so I think that you have made this as clear as it is possible to make it. And I think everyone will now understand why I got confused, because it's pretty confusing stuff. But yeah, so I think we have the standing issue clear enough to move forward and talk a little bit. Can you just tell us about your cause of action? It's relatively simple, right?
Yeah, the cause of action is very straightforward. The question is whether DC consumers, and it's not an individual consumer, there's no subjective test under DC law, but whether DC consumers, people in the jurisdiction, will have a reasonable chance of being misled by the advertising claims at issue. There are, different flavors of that under the statute. The statute has 13 or 14 subparts, and some talk about false statements, and some talk about misleading statements, and some talk about misleading omissions. But the idea of the statute, and if you read the legislative history, its very clear purpose is, are consumers being misled into buying this product? And if there's a reasonable basis under a preponderance of the evidence standard to